This is the Chapter 15 lecture on the Supreme Court, or really the federal court system in general. And if you remember back to our coverage of the Constitution, it is Article 3 that describes the judiciary, and it is rather vague because it left creating the structure for the court system to a later date. That was structured in the Federal Judiciary Act of 1789. This is an act of Congress that organizes all of the lower federal courts. And the original system created district courts for each state and 3 appeals courts or circuit courts. One for the New England region, one for the middle region, and one for the southern region. As the country has grown, so have the number of courts. In the year 2000, there were 94 district courts around the country. That's almost 2 per state. And 13 circuit courts. Now, if you look at this map here, you can see the circuit courts and the regions that they serve. You can see that more populated areas have their own circuit court. So Pennsylvania and New Jersey, for example, have their own circuit court because of the number of major cities that fall into that region. Now, how do federal courts hear cases? Well, original jurisdiction belongs to the lower courts who originally heard a case. It is more often appellate jurisdiction where federal courts hear their cases. The only time that the Supreme Court of the United States has original jurisdiction is a case involving an ambassador or a case that involves a dispute between 2 states. The definition of jurisdiction in this political cartoon, it's kind of funny, the right to exercise legal authority, the extent of authority or control. And here comes a guy running out of a kitchen with a pot over his head and stuff spilling down him and says to his child, "I was just reminded of the fact that the kitchen is under your mother's jurisdiction." So he must have said something that mom didn't like, and so she put this pot over his head. You can see the structure of the court system, and that includes state trial courts, also U.S. district courts, and how the appeals process makes eventually its way to the Supreme Court of the United States. But it's only a request for the Supreme Court to hear a case because they do not have to hear that case. And we will come back to this concept in a few slides. The original Marshall Court, if you remember, heard the case of Marbury v. Madison, in which a judge was trying to declare that they had been appointed to a judgeship by a previous president, that the next president was bound to fulfill that appointment. Not only did they decide against that person, but it established the concept of judicial review, which just means that courts can review and, if necessary, declare actions of the legislative and executive branches invalid or, more formally and more commonly, unconstitutional. The concept of federal supremacy is rooted in the Supremacy Clause in Article 6 of the Constitution, and federal supremacy was solidified very much by the Marshall Court in 2 major cases, McCulloch v. Maryland in 1819, declaring that the state of Maryland did not have the power to tax the national bank, and this was because of federal supremacy. And then in Gibbons v. Ogden in 1823, which, if you remember this, declared that New York State could not grant special privileges to specific merchants in navigating the Hudson River due to the Interstate Commerce Clause that had granted power to the federal government to regulate interstate commerce, and federal supremacy. The state of New York was not allowed to supersede that Interstate Commerce Clause. Now, precedent and the setting of precedent. Precedent means that a prior case whose principles are used by judges as the basis for the decision in a present case. So, for example, in the case Dred Scott v. Sanford, this really, really freaked out abolitionists because it established a precedent that slaves were property and could not be considered citizens. This was only sorted out, of course, because of the Civil War. Another term, Stara decisis, which literally means let the decision stand in Latin, means that a previous decision by a court applies as precedent in similar cases until that decision is overruled, and very, very, very rarely do courts like to overrule previous decisions because they really don't want to rock the boat of the legal system. The only good example I can think of where the court just felt that they were above and beyond justified in using their power to overturn something was the overturning of segregation that had been rubber stamp approved by the Plessy versus Ferguson case in 1896, was later overturned by Brown versus Board of Education, and even more so by the Heart of Atlanta Motel. Brown was decided in 1954, Heart of Atlanta Motel in 1967, and this painting here depicting a little girl having to be escorted to school as schools were being integrated. Stare decisis really is a massively important vocab term to this chapter of study because it shows how reluctant courts are to overturn precedent unless, and the example of segregation is that great textbook example, unless something is glaringly obvious. Now, citizens' legal rights that must be protected. Due process of law and the writ of habeas corpus. The individual being arrested and brought into court needs to be told why they are under arrest. What are they being accused of? Then due process of law, if you are justly arrested and you have been informed, writ of habeas corpus, then you are still entitled further beyond the informing of what you're accused of. You're entitled to reasonable courtroom rights as well. Rights of the accused, such as the right to privacy, which is included in the Fourth Amendment, right against unreasonable search and seizure, also Fourth Amendment, the right against double jeopardy, which is the Fifth Amendment. This means you can't be prosecuted for the same crime twice. The right to silence, you do not have to speak against yourself. That's the Fifth Amendment. The right to property and fair compensation for it if the government is to take it from you. That's also in the Fifth Amendment. The right to a speedy public jury trial and courtroom proceeding rights. That is really summarized as due process of law. That's the Sixth Amendment. And the right against excessive bail or cruel and unusual punishment in the Eighth Amendment. A lot of these things had to be clarified in the 1950s and 60s by the court led by Chief Justice Earl Warren. He had been appointed by President Dwight Eisenhower in 1953. A year later, they decided Brown versus Board of Education. They also decided a privacy case in Mapp versus Ohio, in which if the authorities had illegally entered someone's home, any evidence they found in the home against that person cannot be used against them. Baker versus Carr in 1962 said that congressional districts needed to be of approximately the same size population-wise. Prior to that decision, the congressional districts that predominantly represented black communities had significantly more people living in them than districts that represented white communities, and by saying that they needed to be equal population-wise, this was supposed to level the playing field for all citizens of the United States. In Gideon versus Wainwright, in 1963, a man had been accused of a crime and went to trial, and when he said he could not afford an attorney and he would like one appointed for him, he was told that he could not have an attorney because he was not guilty of a significant enough crime. Well, this went all the way to the Supreme Court, and no matter what you are accused of, you are entitled to representation. Escobedo versus Illinois in 1964 clarified that when a person requests an attorney be present during questioning, all questioning must cease. Escobedo had requested an attorney be present. He was denied that right, and he was therefore set free after this court decision when it was declared his rights had been violated. And Miranda versus Arizona in 1968, a very, very controversial decision, established what we now know as our Miranda rights. Ernesto Miranda had been arrested for and actually admitted to kidnapping and repeatedly raping a woman. And he was, however, set free because his lawyer made the argument that he was never aware of any of his rights, such as the ability to request an attorney, the ability to not speak against himself. So he was set free. This is very controversial because he was an admitted kidnapper and rapist. A couple years later, he was killed in a knife fight in a bar, so he did kind of, in the long run, get what was coming to him. And it's rather unfortunate that people like Gideon or Escobedo, who were not hardened criminals, didn't have the concept of you being informed of your rights named after them. We refer to them as Miranda rights today. Now, how is it that the Supreme Court decides a case? And briefs, so written briefs, are provided to the court. This helps them decide whether they should even hear the case, and kind of a preview before oral arguments in which lawyers argue their case before the court. And it is after oral arguments that the court would then go into deliberations to decide the outcome of the case. Now, what if all justices on the court don't agree? Written opinions are written, and oftentimes you only hear about majority opinions because of the outcome of the case. Well, there are also many famous dissenting opinions in which a justice, or more than one, justice in the minority, writes an opinion of why they disagree with the decision. There are famous dissenting opinions. One in 1857 that had been written by Justices John McLean and Benjamin Curtis against the Dred Scott v. Sanford decision. One in 1896 saying that the decision in the Plessy versus Ferguson segregation case had been wrongly decided. That was by Justice John Harlan. Justice Louis Brandeis argued against the majority decision in Olmstead versus U.S. from 1928, and that dealt with privacy and illegal evidence rights of citizens. Other famous dissenting opinions, Justice Harlan Stone argued in the minority against a decision in Minersville Schools v. Gobitz in 1940, and this dealt with religious liberty and prayer in schools. Justice Owen Roberts, Frank Murphy, and Robert Jackson all dissented in the Korematsu versus U.S. decision in 1944 dealing with Japanese internment camps. Justice Pottert Stewart, another decision on religion and prayer in school in the Abington Schools v. Schempp decision in 1963. Justice Pottert Stewart had written that famous dissenting opinion. Justice William Brennan in 1973 argued against a decision in FCC versus Pacifica Foundation. That was a free speech case. Justice Antonin Scalia wrote a minority dissenting opinion in Lawrence v. Texas in 2003, which dealt with sodomy laws in the state of Texas. Justice Ruth Bader Ginsburg in the rather recent case in 2014, Burwell v. Hobby Lobby. This was a religious liberty case. Chief Justice John Roberts Justices Antonin Scalia, Samuel Alito, and Clarence Thomas. So 4 justices wrote a dissenting opinion in the Obergefell v. Hodges decision, which dealt with same-sex marriage. So some of these, Lawrence v. Texas, Burwell v. Hobby Lobby, Obergefell v. Hodges, these are all rather recent decisions in which there were scathing dissenting opinions written by minority justices. 2 remaining definitions. Judicial restraint. This is that philosophy of we really shouldn't go beyond the clear wording of the Constitution in interpreting the law. This is somebody who would absolutely positively follow that concept of stare decisis and let the decision stand, versus judicial activism, a judicial philosophy that says that the court should go beyond the words of the Constitution or a statute to consider the broader societal implications of its decisions. So can the court legislate from the bench, as judicial activism is often referred to as? That is the end of the Chapter 15 lecture on the federal courts. If you have any questions, by all means, reach out to me. Otherwise, I'll see you in class.